We begin with breaking news. A request late today from the former president's legal team to lift the gag order now that a jury has found him guilty on all 34 felony counts of falsifying business records to keep word of its hush money payment to Stormy Daniels from reaching voters in the 2016 election. As you know, gag order or not, he's already said plenty about the judge, the judge's daughter, and witnesses in the case. Now his lawyers are seeking free rein. CNN's Karis Connell is here with details. Also joining us, best-selling author and former federal prosecutor Jeffrey Toobin, and retired New York Judge Jill Konviser, a longtime friend of the trial judge in the case. So, Kara, what does the Trump team want?
So Trump's team is saying now that the trial's over and the gag order that was put in place to protect the witnesses, the jury, from Trump's comments, now that it's over, they're saying that the judge should lift this gag order. So they write in the letter to the judge, now that the trial is concluded, the concerns articulated by the government and the court do not justify continued restrictions on the First Amendment rights of President Trump, who remains the leading candidate in the 2024 presidential election, and the American people. And they go on to say that they think that there's even a stronger argument now to remove it because President Joe Biden has made comments on the verdict and has Stormy Daniels and Michael Cohen, two of the key witnesses. So the court spokesman for the judge, says the order speaks for itself. The DA's office has declined to comment. I mean, either way, Trump is not prohibited from talking about the trial, talking about the verdict. It's just he's prohibited from speaking about these witnesses and the jury. And the question will be, expect the DA's office will file a response and then ultimately see what the judge does.
Jeff, I mean, is this a reasonable request?
I think it is a reasonable request when it comes to the witnesses. The idea behind a gag order about witnesses is that you don't want to affect their testimony in any way. They have testified. The testimony is over. Also, you have the main key witnesses in this case, Michael Cohen, Stormy Daniels, David Pecker, Hope Hicks. They're all public figures with access to the press themselves. Several of them have already commented. I think it's a little different with the jury. I think judges are very protective of jurors even after they have served, especially in such an inflammatory situation here, and where their identities have largely been kept secret. I wouldn't be surprised if the judge kept the restrictions on the jury in effect. But witnesses, I do think Trump has a good point.
Judge, do you agree with that?
I do. I agree that it is not entirely a crazy request, but it would not be crazy for him to continue the gag order either. Let's remember, the defendant is convicted, but the case has not wrapped up. The defendant is yet to be sentenced, and a judgment of conviction, therefore, has not yet been entered. So I think he'd be well within his rights to do it. But I agree completely that any judge would be much more concerned about jurors than witnesses, particularly public witnesses who have been speaking out.
Would that, Jeff, would that, from a legal standpoint, even exist after whatever the sentencing is? I mean, if can a judge have a permanent gag order protecting witnesses for?
No. I mean, his jurisdiction over this case continues as long as the case is in effect, is pending. This case is obviously going to be appealed. It would then be up to the Court of Appeals to decide if they want to issue a gag order. Frankly, I've never even heard, maybe you have, I've never heard of a Court of Appeals issuing a gag order. So I think this only applies until the sentencing, which is now, July 11th, which is just, a little more than a month away.
So, Kara, when will this be ruled on?
I mean, the expectation is that the DA's team will respond probably pretty quickly, and then I would think that the judge would make a decision. I mean, he has complete control of his calendar, so he could decide to just not rule on it until the sentencing, or he could decide to do it more quickly. There's not really an immediacy to this request. It's not an emergency request of any kind, and the sentencing is about 6 weeks away. So it's really up to the judge to decide when he's going to do that, and if he's going to wait until the end of the proceedings.
And Judge, just in terms of, with sentencing, if the former president was to violate the current gag order, how much would that play into, and his previous violation, how much would that play into sentencing about possible prison time or not?
I think that's an excellent question, and I say that because when it comes to sentencing, the world is the judge's oyster and can consider anything. When you're in a courtroom, when you're making rulings and they're coming fast and furious on evidentiary issues, it's one thing. There are rules to follow. There are really not a lot of rules in terms of sentencing, and a judge can and should look at everything, including what the defendant has said, what remorse, if any, if he's attacking witnesses. The judge should consider that. I certainly would.
And remember, he was found in contempt. I mean, that is a separate violation. And I think it was 11, was it 11 different? 10 different findings of contempt. That is entirely relevant to the decision on sentencing. Doesn't mean he's going to get jail time, but it certainly pushes jail time into a more likely area given a very serious thing that contempt of court is.
Jeff Toobin, thanks. Judge Conviser, Kara Scannell, thanks so much.